Hi, and welcome to Estate Planning Strategies. My name is Todd Friedman. If you're watching this as a on-demand webinar, it's probably because you were either waitlisted for one of our seminars here in Washington State, or because somebody shared it with you, or because I sent it to you, just to give you this information. So this is the exact same seminar that's been given in the local libraries here in Lakewood and University Place. So what I'm going to do is kind of start with a list of some people that you may or may not recognize, and then we'll go from there. For those that know, that would be Red Fox, Walter Cronkite, Barry White, Jacqueline Kennedy Onassis, Billy Martin, Martin Luther King Jr., Michael Jackson, Leona Helmsley, Babe Ruth, Jimi Hendrix. That one's kind of easy, huh? Sonny Bono, Princess Di, Marilyn Monroe, Sammy Davis Jr., James Brown, Jerry Garcia. This is a tough one, but it's Howard Hughes and Elvis. Now, you might wonder why I'm sharing these with you. It's because these are all people that, when they passed, they didn't have their estate plan in order. As you can see, it really doesn't matter what income level somebody is. A lot of us just don't get around to estate planning. That could be why when I put on these seminars locally, they usually sell out within about 24 to 48 hours, and then there's a long wait list. So if you're watching this and you were on a wait list, that's why. This is a topic that a lot of people are very interested in, that they haven't gotten around to doing it. And maybe it's something that they want to get around to. So I guess the first question is, why are we here? And most of the time it's because people know that they should be doing something, but they've kicked the can down the road. They've been avoiding it. Or maybe in some cases, they're just not sure what to do. Most importantly, reasons to do something. Uh, in most cases, it's people don't want to leave a mess behind, either emotionally or financially. During the seminars that I hold, I usually ask for a show of hands of people that have had to deal with an estate, probably their parent or a grandparent, and they share what a terrible experience it was, not only dealing with probate, but also having the government involvement, and then, of course, the costs that are involved. During the seminar, this is a information sheet that are passed out. You don't have one of these with you, so we're going to go ahead and move right along here. Here's a little bit about me. If you're curious, I'm 61 years old, and I live here in Lakewood, Washington, and I was originally born and raised in Miami, Florida. Most importantly, I'm surrounded by a team of individuals that help make everything go smoothly for my clients. I got into estate planning mostly out of personal need, and then I discovered a company called Integrated Trust Systems. I'm going to share more with you about that later, but I've got a partnership with them so that I can offer not only this information, but also access to probably what I believe is the best estate planning platform available in America today. I always like to say bluff, which means bottom line up front. Under the old way, you had basically four options, right? You could do nothing. You could do it yourself, which is kind of what I used to do. You could get a will and think a will is all you need, or you could get a traditional book trust. And we'll talk about a little more why the traditional book trust may or may not be the best option. Now, you still have those four options, right? You still can do nothing. You can still do it yourself. You can still get a will. You can still get a traditional book trust. But now, with the integration of technology and the advancement of some estate planning companies, now we have a digital estate planning platform, which, as I like to say, it's more, better, faster for less money. So, I guess probably the first question is, should I have an estate plan? And why would I have an estate plan? Or why would I go through the hassle of getting an estate plan? A lot of us are familiar with a healthcare power of attorney, right? That would be in the event of an emergency, who can make medical decisions for you? In some cases, we just assume that your spouse can or that your kids can. But unfortunately, because of HIPAA laws and the requirements on healthcare facilities, now you probably are going to need to prove that you're able to make medical decisions for somebody if they've been incapacitated. But what if you've named somebody in your power of attorney? Do you have the document on hand if or when you need it? With the new modern estate planning platform, I have what I call my medical ID card. With that, it's in my wallet. If I actually need medical care, the healthcare facility can log in and go ahead and ensure that they not only know what medications I'm on, what surgeries I've had, they can also see who has the ability to make decisions on my behalf. Another great question is, what if I'm incapacitated? Who can get access to my bank accounts or my retirement accounts if they need money or if I need money for treatment or care? A lot of us think that, well, it's a beneficiary. A beneficiary can do that. That's not the case. A beneficiary uh, can get control of the account only if you pass away. But if you're incapacitated, they don't have any of those rights or privileges. Another question always comes up is, how are my assets going to be distributed when I pass away, right? And when I pass away, if there are no beneficiaries, what happens? Most people have heard the term probate, but they're not really sure what it is and what it means. Well, we're going to talk a little bit later about probate, but here's an example of some of the key features of probate. And probate happens when you don't have a proper estate plan or if there aren't any beneficiaries listed on assets or accounts. And unfortunately, what probate does is it creates not only a burden on your loved ones, but also it creates delays. Your estate becomes part of public record, and it gives people the ability to contest your estate. So we're going to talk a little bit more in detail about probate and how to avoid probate. And here we have on a scale of 1 to 5, how would you rate yourself on estate planning knowledge? And unfortunately, a lot of people do not get around to proper estate planning, which results in 3 million people yearly going through probate. Now, that's about 230 families every day in every state. Would you like to avoid probate? If you would, then you're going to want to continue watching this webinar and you may want to take action. I'm going to assume that we all know how to use Google. So, depending on what state you're in, you can go into Google and ask what the probate threshold is in your particular state. Now, in Washington state, it's 100,000. However, you may have an estate less than 100,000, but you're going to want to have a power of attorney, a medical directive, and a will. But you may also want to make sure that whatever you do own goes to the people that you want it to go to. Once again, we're going to review the 5 options available to everyone when it comes to estate planning. And of course, the first one is do nothing. There's an awful lot of people out there that choose to do nothing, or it's not that they're choosing to do nothing, they just never get around to it. Now, aside from the cost and the delays and the fact that you end up with the government involved in how your assets are distributed, wouldn't you want to keep everything private? The other option is do it yourself, right? There's a lot of information out on the internet. You can Google everything. You could probably find a downloadable document, such as a will or a power of attorney. But then you also want to make sure that if you set up a trust, you want to make sure your trust is funded. That's one of the critical elements that becomes a problem is there are a lot of people out there that may have a trust, but they actually never got around to funding it. And we're going to talk a little bit more about that later. And later on in this presentation, you're going to hear from an estate planning attorney that's going to share some information about funding of the trust. And then, of course, laws always change. Do you want to make sure that your documents are lawful at the time that you pass? Doing it yourself is an option, probably not a good one nor an easy one, um, but it's still an option. Now, third option is get a will. I frequently hear people say, I need to get a will or I need to update my will. Well, did you know that a will is a one-way ticket to probate? Now think about that. You think everything's taken care of because you have a will, but really all you're doing is guaranteeing yourself an opportunity to go through probate because that's how a will is settled. Would that be a problem? Now, the next option is what most people believe is the ultimate estate plan, which is getting a traditional book trust. Now, to be honest with you, I have several clients that are estate planning attorneys and they do traditional book trusts. One of them quoted me $5,000 to do my estate plan, including a trust, and the other one quoted me 7,500 to do my estate plan, which included a book trust. Now, I've avoided a book trust for years, not only years, I'm going to say decades. And the reason why I avoided it was simply that things change, right? I mean, you can change bank accounts. You could change investment accounts. You can buy and sell vehicles. You can buy and sell properties. You may move from one state to another. And every time one of those things happens, you need to update your book trust. What does that mean? It means I have to hire an attorney. It means I have to pay them to make any changes or updates all the time. And you never have any control over it. And you have endless legal involvement and you have endless attorney's fees. For me, I've moved to three different states in the last 20 years. I would have had to redo my book trust every year based on the state in which I lived. Does that sound like a good idea? Probably not. And now a new option is number five. We can utilize technology and we can have a digital estate plan where we still have all of the benefits of that book trust. However, we have full control. So I can literally log in and make any changes I want to in my estate plan, hit save, and it's all updated and it's all current and it's all based on laws today. Now, what's really nice about this digital estate plan is it's actually lower cost than the traditional book trust, but for a nominal annual fee, I can actually make updates and changes and get unlimited legal help as part of the program, which is absolutely fabulous. So you may want to, as you're considering some of these options, you may want to look at the digital estate plan because it offers all of the benefits that you want and need to include power of attorney, medical directive, will, revocable living trust. All of those things are all included in one basic platform. Now, if your estate is over 100,000 here in Washington, or whatever amount it is in the state that you're watching this, the reality is you have two choices, right? You can either do the archaic traditional book trust that the day you do it, it's obsolete, or you can go with a digital option which has full control for you as the grantor. Here's what's kind of interesting. We've all probably heard that most of your major corporations are incorporated in Delaware, right? So let's say Boeing. Boeing has a lot of facilities here in Washington State, but they're incorporated in Delaware. Why? It's because of legal protections and tax advantages. If you aren't familiar with the term jurisdictional shopping, it basically means that we can shop in other states and make transitions outside of our state legally, right? And so, with that being said, a lot of corporations are based out of Delaware because it's more advantageous to the corporation. Well, when it comes to trusts, my trust and all of my clients' trusts are based out of Nevada. Why? Because Nevada is the most advantageous for trusts and estate planning. They've codified all of the laws for electronic signature. So whether I live in Washington Or if I choose to move to Arizona or Florida again, my trust and all of my estate plan stays the way it is because it's based out of Nevada. Now, what I'm going to do is share a video by Mo Dodka. Mo is actually the president of Integrated Trust Systems, and he's an estate planning attorney. You're going to want to listen closely to this 15-minute video.
Hi, my name is Mo Dodka, and I am Integrated Trust Systems General Counsel. I'm sorry I couldn't be there in person today, but I did want to take a little bit of time to go through the law behind what we do at Integrated Trust Systems. I've been an attorney for over 15 years in the areas of estate planning, real estate, and corporate law. I was that attorney that was doing the traditional estate plan. I was the attorney that was providing book trust to my clients. When I found out about what Integrated Trust Systems was doing for the clients of their platform, I had to learn more. Since that time, I've migrated my own firm's clients to the platform. I've also migrated my own family's trust to the Integrated Trust Systems platform because of all the great things that they provide for their clients. I'm going to go through some of those great things and some of the law behind Integrated Trust Systems estate plans because I know that estate planning can be confusing. So here we go. You've learned a lot about different scenarios today from your host. We're going to go through the three general options most people have when it comes to estate planning. Option number one is do nothing. If you do nothing at all and you pass away, you die what's called intestate. You will have to go through the court system, and every state has its own laws for how your property will get distributed. Sometimes it'll go to kids. If you don't have kids, it might go to a spouse. Sometimes it goes to your spouse and kids. Sometimes it goes to parents. You have no control over how much or how little goes to each of those people. The law will decide where it goes. Option number two is to do some simple estate planning in the way of a will. I'm going to go through why a will typically is not the answer. Most people have thought for some reason that having a will alone is enough. A will is usually a one-way ticket to probate, and that's what we're trying to avoid with proper estate planning. Option number three is to do a proper estate plan. In our case, 99 out of 100 people that we talk to fall into the category of having a revocable living trust. And we're going to get into the law behind that. A properly funded revocable living trust avoids probate altogether and gives you latitude to do anything you want with your property during the time that you're alive. So options number one and options number two usually end up in probate and usually lead to having very little control over what happens to your assets when you pass away. So what is probate? What's the scary word probate that you've heard about multiple times throughout this presentation? Well, probate is that long drawn out court system that your loved ones and beneficiaries have to go through to gain access to your property and assets after you pass away. What's the problem with probate? Well, with probate, we have a couple different problems. First problem is it's expensive. Depending on what state you're in, it costs money to go through probate. Normally, you have to hire an attorney, and that attorney will go through the probate system and the court system, make a filing, and court systems are typically backlogged. So usually there's going to be some delays. The other thing it sometimes leads to is family disputes. You'll be gone, and we don't want your loved ones having to fight over what you've left them. Hopefully, nobody's fighting over their loved ones' belongings, but I'm sure you've heard those stories of people who are fighting after their loved one has passed away. Unfortunately for me, being in the law profession, I've seen this go very wrong. People get a really bad feeling when they hear about divorce attorneys. Everybody knows a divorce attorney they don't like. Why do divorce attorneys get a bad reputation? Normally, they get a bad reputation because they're taking advantage of a scenario where somebody is going through a difficult time and they know it's a way for them to capitalize and make some legal fees. I'm not saying every probate attorney out there is this way, but when you pass away and family begins to fight, it's a very similar scenario. So with proper estate planning, we avoid this altogether. We avoid your loved ones during a time of sadness and grieving to have to go through a long drawn out court system. So proper estate planning avoids all of this altogether. Where do you want your dollars to go? Do you want them to go to the state or to an attorney, or would you rather them go to your family members? The answer is typically, I would rather it go to the family members. So remember, if you have a will alone, the likelihood that you end up in probate is very, very high. So why did somewhere along the way people think a will is enough? We really don't know. Most of the time, people think having a trust means you have a lot of money. The vast majority of states in this country, if you have anywhere between 40 or $100,000 of actual net worth, you end up in probate, or your loved ones will end up in probate when you've passed away. The idea of having a trust fund or being a trust fund baby is something the media has glorified. You don't have to be wealthy to have a trust, and having a will alone is usually not enough. So, if you're not going to have a will, what would you normally want to have? And that's a revocable living trust. A revocable living trust has two main benefits. Benefit number one is that probate avoidance, what we just spoke about. You need a properly funded revocable living trust to avoid probate. I'm going to touch on funding in a second. Benefit number two to a revocable living trust is that by its name, it's revocable, it's amendable, it's changeable. You can make as many changes throughout your life as you want to your revocable living trust. You should make changes to your revocable living trust. Life takes you in different directions. You might have more children, you might have grandchildren, you might love somebody today that 5 years from now you don't love anymore. There might be a new charity you want to leave something to. Your life is going to take you in different directions. Having an estate plan that you can make changes to throughout the duration of your life so that it works for your life's need throughout your life is very important. And a revocable living trust allows you to do that. It also allows you to take the benefit of new laws. As laws change, you can change a revocable living trust to take advantage of those new laws. And if laws get worse, on our platform, Integrated Trust Systems, we will create language to try to circumvent as much as we can those bad laws at no cost to you. So what's the difference between coming to Integrated Trust Systems to get your revocable living trust or going to the traditional law firm? Well, remember I said you need a fully funded trust to be able to avoid probate? At a traditional law firm, you're unlikely to get your trust funded. What is funding? We don't mean you need to pour money into a trust. You need to assign assets to this trust. Your trust must have your assets assigned to it. If you pass away and you haven't assigned your assets to the trust, even with a revocable living trust, you could end up in probate. So why do law firms not fund trusts? And if you've been to a law firm or you speak to a law firm after this meeting, ask them if they fund. The vast majority of them won't. My law firm, when I was doing book trust and traditional estate planning, didn't do funding. Why? It's long, it's cumbersome, it's difficult to do. At Integrated Trust Systems, using our digital platform and using Nevada law, which I'll explain to you in a second, we are able to fund your trust immediately, quickly, and allow you the tools to keep your trust funded throughout your life so that you do take advantage of that number one advantage of having a revocable living trust, probate avoidance. Second, remember I just said you want to make as many changes as you can throughout your life to make your trust work for you? With the traditional law firm model, you have to go back to that law firm, you have to request that change, and you have to pay an hourly fee. Every single time you make a change, you have to pay an hourly fee. On our platform, you use our notepad system, you request assistance from our legal staff, and we make those changes for you, or you log in if you feel comfortable and make the changes yourself at no additional cost. We encourage you to keep your trust funded throughout your life. We encourage you to make changes on our platform, and we don't charge you for those changes. Imagine going to a law firm every time you wanted to have a change made on your trust, and then add up all the hourly legal fees that you would have to pay to make those changes throughout the duration of your life. Also, you can make the changes from anywhere. You could be on vacation and make that request and make those changes. You don't have long wait times to meet with an attorney. You don't have long wait times for them to recreate the documents, print them out, and have you in their office. The changes can be made effectively, quickly, and at any time from anywhere. You also have access to your documents from anywhere. Our document management system allows you to have your documents in one clean place. If you want to print them out, you can. We also hold all of your documents for your trustees. Those are the people who are going to be settling your estate when you're gone. We're going to talk about that role in a second as well. So why do law firms not provide this service? Why don't they provide digital estate plans? Why don't they fund trusts? Well, law firms are really honestly stuck in their way of doing things, in the way they've done things for centuries. I When I got introduced to integrated trust systems, called my law partner, who you might meet if you're a part of our platform, his name is Tim. And I said to Tim, Tim, I think we've been doing things a little bit wrong. And I'm going to change what we do and move to integrated trust systems. Tim is a fun guy. He's a funny guy. He said, I am not fully comfortable doing that. And I asked Tim one question. I said, Tim, you have a revocable living trust. Is your trust still funded? And he laughed and he said to me, it's not. So I said, your family would likely end up in probate if you passed away tomorrow. And he said, probably. And I asked him another question. I said, if your trust as a partner in our law firm is not still funded today, imagine how many of our clients are probably walking around and their trust is not fully funded and they will end up in probate. So when I learned about all the benefits of the integrated trust systems estate plan, I had no choice but to switch my clients over and switch my own family's trust to the integrated trust systems estate plan. So who's involved in a trust? You as a grantor are going to be the first and probably the most important person in a revocable living trust. You have full latitude and control throughout your entire life over all of your assets. You can sell them, you can keep them, you can add to them, and you can continue to assign them to your trust. You do that for the benefit of your beneficiaries. Those are the people that you are leaving your legacy behind for. Those are the people that you're leaving those assets behind for. And when you pass away, you want to make sure that all the hard work and all the assets that you've accumulated throughout your life is left for those beneficiaries. Throughout the process, you will select people like a trustee. That trustee will be the person who's going to help facilitate that transfer of assets after you pass away to your beneficiaries. We'll discuss what a trustee's role is more when you join our platform. We also provide for you not just the revocable living trust, but all of your medical directives, all of your powers of attorney. So if God forbid you're in a hospital and you can't make decisions for yourself, we make sure we have all the documentation in place so that somebody that you choose can do that for you. You want to make sure that in a proper estate plan, you take care of all of the worst case scenario, what if questions. So how do you avoid probate? You get that revocable living trust. How do you avoid all those worst case scenario situations? You get all the rest of the documents that go into our integrated trust systems estate plan. Now, you might have some questions about why we use Nevada law, and you might not be in the state of Nevada. So how can we use Nevada law anywhere in this country? Well, the US Constitution's full faith and credit clause allows you to create your trust under the situs of any state and take it with you to any other state. Why are we allowed to do that? Well, we are people that move around the country quite often, and we live in a great country that allows us to do that with as much latitude as we want. I actually reside in a very cold place called Chicago, Illinois. The winters are pretty cold. Someday I might get tired of that, and I might want to move down to Florida or Texas or Georgia. If I had to move down to another state, every time I moved, I had to create another trust for myself. That would be pretty unreasonable. So the law allows us to create our trusts using the situs of any state and take it anywhere. So why did we pick Nevada law? Well, it's the best law for you, the grantor. It has the most protections for you. It has the most ease in funding. And it's the law that most people would choose if they had a choice. And the nice thing is you do. So you can take a Nevada trust anywhere to any state in this country and use it effectively. It's the same as why some companies use Delaware as their incorporation state. They might operate in different states, but they use Delaware. It's because the law allows them to do that. So why not pick the best law? We did, and we choose Nevada as the law to create your estate plan, and you can use it in all 50 states. So I said, our estate plan is more than just a revocable living trust. Here's a list of some of the things that we provide. Your host spoke about the medical directives, spoke about the medical ID card that you get to carry with you. But here are some of the other things that we provide. Again, you're going to have all of your financial powers of attorney, your healthcare directives, the revocable living trust, access to a 24/7 platform where you can make changes at any time, access to a notepad where you can communicate with our staff and our attorneys when you're confused or you have any questions. We allow you to share your console with outside attorneys. We allow you to share your console with family members if you want their input. And we allow you the access to restrict everybody from your estate plan if you choose to do that. Our platform is comprehensive, it's modern, and it's accessible anywhere you go. So, what if you already have a trust? Well, if you already have a trust and are interested in moving over to the Integrated Trust Systems estate plan, we can still help you. We can recreate a new trust for you, either restate your old trust or start from scratch. The benefits that we provide for you to be able to keep your trust funded throughout the duration of your life is above and beyond anything in the market. We are not LegalZoom. We are a platform that creates comprehensive estate planning for you and your family's needs. And we would love to have you be a part of our platform going forward. Thank you for taking the time to learn about integrated trust systems and our estate plan. It's an effective, more modern approach to estate planning. I know you still might have some questions. I know there's specific scenarios that you're thinking about right now that pertain to you and your family. If you have questions, please take the time to meet with your presenter and your host. We are a resource through their office. We hope to see very many of you on the platform soon, and we hope to be a part of your estate planning needs.
Thank you very much, Mo. Mo actually is the estate planning attorney that we work with on our estate plan. And I have to say, him and the other attorneys at ITS are absolutely fabulous. So, once again, remember, we've got basically five options. Do nothing, not a good idea. Do it yourself, not really a good idea either. Get a will, one-way ticket to probate. And then we're talking about whether you get a traditional book trust, which is I'm going to say, expensive and archaic way of doing estate planning. Or you can use the digital platform that Mo just talked about and that I shared with you. A little bit about integrated trust systems. They've been around since 1985. This isn't a technology startup, company. They've been around for a long time, and they've been doing estate planning and have evolved to a current modern digital platform. So phenomenal firm and a partnership that I not only feel good about, but I feel very confident that having an estate plan with them is the most optimal decision you can make. So if you'd like to explore some of the different options, as well as talk about whether the ITS digital platform may be a good fit for you, after you finish watching this webinar, please feel free to reach out to me to schedule either a phone call, a Zoom chat, or a meeting in my office here in Lakewood. Mo touched on this. If you already have a trust, we can easily transition you to a new trust with ITS, or we can do a restatement of your existing trust and put it on a more modern digital platform. What do we do now? Well, after the seminar and the workshop, you have two options. You can take advantage of one or both. The first item is if you'd like to talk about estate planning, there's a no cost, no obligation strategy meeting where we can review what may be the best option for you. And then the other is I actually do retirement planning. I'm an investment and insurance specialist. So if you'd like to just have a retirement readiness review, I call it the Ask Me Anything meeting, where no obligation, no commitment. More than happy to just kind of do a review and share an opinion with you. My consultation times are listed there, and my office is in Lakewood. So once again, this concludes the webinar. I appreciate you spending the last probably 45 minutes with me. My email address is there. And once again, just as a recap, uh, the two main options that you have are the traditional book trust estate plan, or you can have the integrated trust systems modern digital platform. And like I mentioned earlier, their platform, I call it more, better, faster, for less money, meaning that it's significantly lower cost than the archaic old traditional estate plan. However, it's more effective, more efficient, and most importantly, you have full control. So I look forward to meeting you in person or by Zoom or virtually, and hope you found this useful and have a great day.